Ladies and gentlemen, the American Jury and Bulldog Nation, be sure to subscribe to the Bulldog Show on YouTube. Today's short seminar is a legal seminar is about class actions. You've heard the word. I'm going to explain what they are and why they are. I think that one of the things that you need to understand why they are allowed, the concept for a class action is to allow a whole lot of claims that are similar to proceed together to save court system and the parties time and trouble. You may not know this, but one of the creators of the class action in the modern era is Stan Chesley. He deserves credit. You know when he started it? The Beverly Hills Supper Fire Club. That's when he developed the concept using other historical use of what would be kind of like a class action, but he helped create the whole concept of class action. Many people thought he was crazy, but on behalf of all of those victims who died in that fire, they all died from what ended up being a aluminum wiring issue and other issues. Many companies settled, and he got a resolution for all of those people. Just imagine if one of them had to go to trial one at a time. By the way, in medical malpractice cases in Kentucky and Ohio, they're not allowed. The Durrani litigation, for example, is over 500 individual cases. It's not a class action because class actions are not allowed. By the way, they should be. Class action is a group of people who are similarly situated that have similar injuries. That's the little tidbit that they say, reason why they don't allow medical malpractice, because everybody's injured differently. It's really a farce. The rule that's in most states, in the federal civil rules of procedure, they call them, is Rule 23. And that's a rule that was developed with the help of Stan Chesley in the Beverly Hills Fire Supper Club case. The first component you need is what's called numerosity. A lot of people. Makes sense. The second component is commonality. They all have a common cause of action. Third is typical. In other words, they're all typical, and you have a class representative, which I'll get to in a minute, that is typical of everybody. Adequacy, that the class can adequately represent that group. You see all these class actions filed all the time. Deters Law, for example, has a class action that's certified against St. Elizabeth Medical Center for a billing practice where if you went into your primary care physician for one issue and you asked about another issue, even though you were there, anyway, they'd bill you for 2 or 3 issues. That's been certified as a class action. The advantages of a class action is to take care of a whole lot of claims at once. So you don't clog up the system with 10,000 lawsuits. You have 10,000 claims brought as a class action. There's always a class representative or a group of class representatives. One person. That one person represents the class. They have to be adequately with knowledge, and their case has to be similar to the others. And they're the ones that work with the lawyer the most. It's called a class representative. The courts determine who the class representative is. The next step, when you start out a class action, you file it, you will conduct discovery, depositions, do some things. The goal is to get the class action certified. That's where a judge says, I'm hereby certifying this class. And the class has to be defined. Who is in the class? In the St. Elizabeth Medical Center case I just spoke about, anybody who went to the primary care physician at St. E's during this time period had this happen to them. The class gets certified. Most class actions get resolved once the class is certified. The battle is getting the class certified and keeping it certified. Class counsel. The lawyer that brings the class action is usually appointed to class counsel, but it's up to the court to decide who's class counsel. They have to be competent. It's better if they're experienced, but sometimes you got to start somewhere. Every class action lawyer started out being their first class action counsel. Settlement. I've already discussed that. Most settlements happen after there's a certification. And you read about those in the paper all the time. Before it's class certified and after class certification, the parties are allowed to conduct discovery, take deposition, get documents. Can you imagine what the discovery's like in the Johnson & Johnson talc powder case? Think about all of the discovery, the smoking litigation against the tobacco companies. I mean, you're talking warehouses full of paper. And you know what? You got to have bodies that go through and look at every piece of paper. Trial. I've already covered that. But a trial could be held. A trial in a class action could take months, could take a year. Opting out. Most class actions allow for a party to opt out of the class. I'll tell you right now, settlements don't happen very often. When that happens, there's a lot of strings that get tied to that. But usually you're allowed to opt out and proceed on your own. However, when there's a class action and it's certified, many times it will be binding upon everybody. Corporate America. This will not shock you. Ladies and gentlemen, to the American jury, corporate America doesn't like class actions for obvious reasons. It gives recourse to a bunch of injured people quick. Corporate America likes to delay, deny, and defend. The 3 Ds. Legal fees and costs. When it's a class action, the court gets to approve legal fees and court costs. Multi-state jurisdiction. This is the rage of American jurisprudence right now, is that these cases ended up being not really class actions, but multi-district jurisdiction, and they got it set up to where one jurisdiction will be picked where all the cases are consolidated. Then they have these big groups of attorneys, the big shots, and they all get together and they're all part of this committee that manages it. But what it ends up being is not a class action, almost like a hybrid class action. The end result's usually the same. What oftentimes happens too is they pick out one single test case to go to trial. They've done that on the Johnson & Johnson talc powder cases, and the verdicts have been pretty good for the plaintiffs. The idea is to test it, to see, are these cases viable? And then you get more and more pressure from the court to settle. Class actions are meant to be efficiency. Avoid 10,000 lawsuits. I've already covered that. They also are meant to change corporate behavior. You know, the plaintiff's bar gets a bad rap. I could go through a laundry list of American corporate policy that changed based upon class actions. Ford Pintos, you don't have rear-ended cars exploding anymore. The wearing of seat belts, safety, airbags. Look what the Beverly Hills litigation did for safety of buildings. No locked doors. Class actions have saved lots of American lives because they changed the policy of corporate America. And folks, corporate America, you can only hit them in one spot, their pocketbook. Let me tell you something else about class actions. They usually are against the largest of our corporations. What I like, nobody ever uses the word medium businesses. Small and medium businesses, you don't get hit with class actions. You know why? You probably don't do things where you deserve a class action. Coupon settlements. One of the pet peeves of class actions is the lawyers are the ones that make money and everybody gets a $5 coupon to Papa John's Pizza or something like that. They are pretty absurd. Finally, a class action can be both in state and federal court, depending upon whether there's federal jurisdiction based upon what's called a federal question or federal diversity. Generally, the corporate America wants it in federal court. Usually, the plaintiffs would like it in state court. There's a difference in what juries normally do. So, ladies and gentlemen, the American jury and Bulldog Nation, if you think you might have a class action, and by the way, recently, I know some people that come to Deters Law, get Citibank, they got screwed on their credit card, they're asking for class certification. So if you have encountered something that you think might be a class action, contact an attorney. I personally recommend Deters Law. So ladies and gentlemen, the American Jury and Bulldog Nation, I hope this gives you a little more detail what class actions are all about.